So first we'll have Professor Nico van Eyck, which is the director of the Institute for Information Law, IVIR, Faculty of Law, University of Amsterdam, followed by Mr. Tal Goldstein, Head of Strategic Planning and System Analysis, the Israel National Cyber Bureau. Then we'll have Ms. Esti Peshin, Director, Cyber Programs, Israel Aerospace Industries, followed by Mr. Jochanan Sommerfeld, CEO of Comsec Group. Then we'll have Professor Dr. Gerald Spindler, Department of Commercial Law and IT Law, Göttingen University. And last but not least, we'll have Professor Tal Zarsky from Haifa Center for Law and Technology and University of Haifa, with including myself, currently a fellow here at the Minerva Center and at the Berkman Center at Harvard. So, Nico.
I think this is the largest panel, but I really admire you for still being here. It reminds me of this famous panel of the Université d'été de Carcan-Maubuisson, where we were supposed to talk about Dutch media, which is an incredibly boring topic, and there were more speakers than there were people in the room. And at the end of the session, the room was completely filled, but that was because a famous French minister was speaking after us. I will not really talk about critical infrastructures because I have prepared something else. I, however, could talk about critical infrastructure, so maybe if there are questions, I can address them. What I will do is I will briefly talk about a study that we conducted quite recently on what's also on the presentation, the topic of standards for oversight and transparency in national regulation. And before I do that, I first want to share 2 slides with you. Let me see whether everything works. Oh, that's this one, another one. I think a lot of the issues that we are talking about today are linked to the commodification. Are linked to what you could call the commodification of the internet. Real life problems have entered the era of the internet, and we now have to find out how to deal with them. And from a conceptual point of view, I often think it's about peeling the onion. We have existing concepts or existing rules, and what you need to do is to go back to why do we have these rules, what is the normative basis behind these rules, and then build up a new onion to understand how these things work in an internet-related environment, a data environment. Like I was telling people today, this is the last month that we can talk about big data, because starting the 1st of January, we're all supposed to talk about Internet of Things, or maybe something else. But national security and mass surveillance. This is just an impression of all the players and all the topics at stake. Like Joel, I'll stole most of them of the internet, with the exception of one. That's the one in the right corner. That's this one. This is a picture I took myself. That sometimes still happens. This was a cake that was given to us at a conference organized by the Dutch military on cyber warfare. And these are soldiers carrying laptops. I don't know what you do with laptops in a warfield situation, but still, and I don't think that this is how the guys look that do digital warfare when they sit behind their desk and use their portables, nevertheless. I ate the cake, but I made a picture before. And actually I have a whole collection of cakes that have little logos on it, because it turns out that that's a thing at a lot of Dutch events. My whole story is actually about the core of regulation in the context of national security, mass surveillance, and that's where it boils down to what I call the dilemma between special powers and special legitimation. And we generally accept in jurisprudence, but I think also in the common debate, that there is relevance to national security, that special powers need to be in place, but we also, and that's where the group becomes smaller, we also agree on the fact that the rule of law needs to be respected. And rule of law in this case means that in case of special powers, you need special legitimation. And therefore, you need an appropriate system of checks and balances to put in place. That doesn't exclude that there can be very special circumstances. I think the Paris situation is one example where the French government decided to officially declare the state of emergency, allowing them to take measures for which they don't need approval beforehand, but where they need approval after, as soon as possible. But nevertheless, we have special rules for exceptions in war, in states of emergency. By the way, the Dutch Prime Minister, during the first press conference after the Paris attacks, said that we are now in war, which for a lawyer is really difficult to understand, that the Prime Minister just can say we are now in war, because that would mean that there is an official declaration of war, that you have an enemy, etc., etc. But let's not be too legal. So how to determine these dilemmas and how to deal with these dilemmas? The first thing you do, of course, is look into where are our core values, and they are normally supposed to be enshrined in a constitutional framework. Europe has two constitutional frameworks. One is the famous Council of Europe in Strasbourg with the European Convention on Human Rights and all these beautiful articles, and the second is the European Union. European Union, who had no fundamental framework, and to some extent a lot of people in Brussels still have a problem with that, because the European Union was originally the European Community of Coal and Steel. That's what a lot of people still think is the most important aspect. Trade, merchants, that kind of stuff, crossing borders to do international commerce. However, under the leadership of a guy who turned out to be also accepting diamonds from a dictator in Africa, we came up with an EU Charter on Fundamental Rights. And we never expected that to play a very important role. It was mainly a political process. For those who know a little bit of the history, the Strasbourg Convention was made by academics, highly respected people in society. The EU Charter was sanctioned off by a bunch of politicians who don't think in, let's say, what are the real aspects, the real consequences in a long-term situation. Some nice articles, actually very similar to the Strasbourg structure. And what then happens is, of course, and with the development of the internet, that new questions are put in front of the courts. The fact that a lot of these cases are very recent is not because courts have become more activist. That's another thing that might be there, but it's just simply due to the fact that these issues first started 5, 6, 7, 8 years ago, and it takes a very, very long time before cases go to court. In the case of the European Union, the Charter only entered into force in 2009, 2010. We're now 6 years later, so it's totally obvious that internet-related cases are now being dealt by the court. However, about the activist part, I do know that several judges also see this as a really unique opportunity to offer a better framework for coherence within Europe, to really discover the importance of underlying values. And these, I think, are the three main cases that, in the context of this conference, are relevant. There's the famous Digital Rights Ireland case. That's the case about the data retention regulation, where the court took the decision to take down, to declare invalid this directive. And declaring instruments of European law invalid is the ultimate exception of the exception of the exceptions. It almost never happens. They even didn't follow the advice of the Advocate General, who said, well, let's give the member states a certain period of time to repair. No, court made a very, very explicit statement by invalidating the data retention regulation. And then we had the Schrems case. This is Schrems, but the picture is very important because this picture was made at a conference that we held a few weeks ago, and Schrems was our keynote speaker, and this was just the week after the decision was made. So Schrems said, I've never spoken in a church. This is the church of the University of Amsterdam, the main hall, also a church. And he felt like a priest doing a religious speech, more or less. Then, much more recent, last Friday, this case is still not discovered by lawyers. Almost nobody has reported on it. This is a very, very important case. The Zagarov versus Russia case, a decision by the European Court of Human Rights. I think this is Mr. Zagarov. I tried to find him on Google, but I couldn't find really a picture that said this is him. So it might also be a family member of the famous other Zagarov that they had in Russia. I don't know. But this guy, in 2006, asked to be informed or started a court case about the fact that his mobile phone was allowed to be listened in due to surveillance legislation. And in Russia, there was a lot of legislation, both on law enforcement using access and technological means to have access to data, and of course also the Russian National Security Agency. The decision of the court is very clear. I advise everyone to read it, and what I'm going to tell after this slide is more or less what also is reflected in this case. What I do want to stress out is that when the decision was announced, so not pronounced, that happens a few weeks before, his office was being raided. And just a few days ago, Russian parliament has accepted a law that says that the decisions of the Russian Supreme Court can supersede decisions of Strasbourg and international courts. So all this cannot be a coincidence. So our report about oversight and transparency. Free copies still available. Normally they would cost like 40 euros. Why did we do the research? Well, mainly because we didn't want to do traditional legal research. We wanted to have impact. We wanted to also do what economists do. So you make a graph, you have 3 points here, 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 and then you predict that the next point will be there. So that's what we did in this study. We took the jurisprudence, we took policy reports, and we said, this is where we think the standard is going, and this is what is the standard that should therefore also be included in legislation, in regulation, and anything that is relevant. And all these things turned out to be working quite nicely. So I just give you a few of the 10. They're all in the report. One of the important things is that that surveillance and oversight on surveillance should be a 360-degree business. So it should be complete. So not only in the policy aspects, but also in the practical aspects. It should cover the process from the start to the actual actions and to the final assessments afterwards, whether things worked out the right way. This is not a very unique standard, but it's a standard that turns out to be very helpful to determine whether there are gaps in the whole process. It's a little bit similar with the second one. Oversight should encompass all stages of the intelligence cycle, so not just focus on the processing of data, but also include the collection of data. There were some remarks made earlier today, which are typically the remarks that you hear from intelligence agencies say, well, we should not discuss anymore the collection of data. That's gone. Only discuss the processing. No. There's a very, very simple reason for that. If there is no money in the bank, banks don't get robbed, unless bank robbers are incredibly stupid. I think that's the most simple way to explain why collecting of data should still remain an issue of concern. Oversight should be independent. This is one of the hardest issues to deal with. We now know, thanks to the Safe Harbor decision, that oversight is something that we have to take into account. Implicitly, the court has said oversight in the US is not complying with the standards that we have set out in this earlier data retention decision. But the horrible thing is, the court didn't decide on American standards of independent oversight. No, it decided about independent oversight in general. And now the big issue is, do European countries actually comply with this criterion? And there was a recent report by the Agency of the European Union on Human Rights, and that report clearly shows that Europe is an incredible mess. And the easy examples are your own examples. In the aftermath of the data retention decision, the appeals court in The Hague had to decide on the fact that lawyers can be wiretapped, without a judge being involved. This is in the context of national surveillance, so not in the context of law enforcement. Law enforcement, there is a warrant needed. This means I have still 3 minutes. Self-regulation, yes. Because we are 6, and then I think we have to be precise. So this is where the question was asked: is it allowed that lawyers are being wiretapped without a order of the court? And the Dutch court said, no, that is not possible. The oversight system we have for the National Security Agency is not compliant with what the court in Strasbourg has said, which means I hereby officially declare the Netherlands are a rogue country. We have a system which is definitely not complying, and now the big issue is what are we going to do with that? But that's not a unique situation. There are many more countries in Europe who have the same problem of lacking independent oversight. This is again confirmed in the Russian case. The fact that you have everything written down in a law is not enough. There needs to be, as part of oversight, also a specific remedy. So oversight committees need to really be able to enforce what they are saying. And therefore, they also need to have a situation where measures can be declared unlawful, where redress is being offered, and where the advocacy principle, I always have problem saying that, the advocacy principle is included. The advocacy principle is lacking in actually most of European legislation, which means that, yes, even with a wiretap, a district attorney goes to a court, but the court can only listen to what the prosecutor is saying. There is nobody else coming in saying, I think there might be something wrong. And particularly from a technical point of view, very often mistakes are being made. Like there's an order to tap a IP address, but that's not a static IP address, so that IP address in the meantime has shifted to someone else. So following the order means that you're actually wiretapping the wrong person. And last but not least, at least in the context of oversight, it should be effective and there should be sufficient resources. It's one of the interesting elements also in this Russian case where on the one hand, the law is like, it's a dream from a Dutch perspective. Everywhere courts have to be involved. But those courts, whenever they get a case, dismiss all the cases. Or they don't exercise their right to really look into the files. And partly that could be because they are very much following what the government likes, but it could also be because they have very, very limited resources. I stop here. The other 4 are about transparency, also an interesting topic, but I want to keep my 15 minutes. Thank you.
Hello, everyone. Actually, I plan to talk about our strategy for national security, our 3 layers strategy, but I decided to be disciplined and to talk about critical infrastructure. So I will do my best to give my own perspective on the Israeli experience on cybersecurity in critical infrastructures. And I think that, of course, the first very important milestone is 2002, when the government of Israel decided to give the Information Security Agency within the Shin Bet, the Israeli Internal Security Agency, the responsibility to protect critical infrastructure or computerize critical systems. And this resolution is based on, actually it's 1 year after 9/11. And it's based on the understanding that event like 9/11 might occur again, and a group of people that came together in a room trying to think what might be the next 9/11 came out with the idea or the threat that specific system, critical systems, attacks against those systems can cause events similar or even worse than what we saw in 9/11. And so this is why they build this very unique, I think, model where internal security agency is responsible for regulation on critical infrastructures in what was not called yet cyber, but we call now cyber. And I think it was a very good model, very much because of its size. It's very small number of organizations that were under these regulations, which means that those regulations could be both very restrict, okay, because we can look at the organization and tell them exactly what to do because this is a critical infrastructure, most critical, and so we can be very strict, but also tailor-made. What we've done in the last 15 years is very tailor-made regulation, working together with the organization, putting them into a process of improving their security. Again, in a very small number of organizations, it's possible. And the first lesson that I take from that is the importance of the process. It's not just the standards, okay, because if you put a standard, it's relatively very static. You must be dynamic. You must work with organizations all the time. You must understand that they need to operate. If I regulate the electric company in such ways that will affect the way they operate, it will be worse than if they won't be secured. So I must work with them to make sure that they will operate as much as they should be, but still be as much secure as they can. The second lesson that I take from this is the importance of the connection between regulation and operation and technology. Okay, because this unit is part of intelligence agencies, they have the modus operandi of connecting between operation and technology into this mission. And this is something that we learned that was very effective, because if you are working on the operation, working on dealing with the threats, then your understanding of the need of the organization, of the next regulation that you must develop is much higher. So this is the first milestone of the National Information Security Agency. 10 years after this decision, the government decided to establish the National Cyber Bureau. And this resolution came from the understanding that we cannot look only on the critical. The situation today, and especially when we look at the future, it's that the dependency on cyber system and the threat from the other side is such that the threat to the nation is not just from those very few critical infrastructures. That attacks and threat can come from various kind of organizations, and we must have much more broad and comprehensive approach on how we improve the national security. And this is why we decided this year to establish a national cyber authority that will be responsible for promoting the cyber security of the whole nation, whole market. And the reason that we decided we need a new dedicated body is threefold. First of all, we need someone that will be responsible for all kind of for all the three layers that I think you've heard about earlier, from the robustness, helping organizations to secure themselves, to the resilience, helping them deal with the attacks once they had been attacked, and for the defense, for facing the attackers, and I will comment on that later. The second reason is that this is a new discipline, and we must build a unique organization, dedicated organization that will evolve, that will learn, that will adapt to whatever coming on in the future, because I must say, we don't understand the cyber threat 5 years from now. And we must have the ability to adapt from different kind of threats or different kind of actions that are required. And the third reason is that we understand the importance of having a very open civilian organization that will be able to work with civilian organization together, as I said before, and because it's responsible only for cybersecurity, everything it does is for cybersecurity, we believe that its ability to work to protect civil rights will be much greater. 3 points I want to emphasize about the way that I think that this organization needs to look on the security of the market and critical infrastructure, and actually what is critical. In my opinion, we have the most critical, of course, but to differentiate between critical and not critical, I believe it's not the right way, because we can never know from where the attack will occur. We believe in a differential approach, going on from more critical to less, but looking at the entire picture, trying to build what we call a systemic robustness. Okay, to make sure, if we make sure that the entire market will be more secure, then each of every of the organization will be at the end more secure, because the entire system will be more secured. And the third point is that I think that we must look beyond the organizations, and this is what we call the third layer of defense.